with its last two terms bringing down significant rulings on issues like abortion, student loan forgiveness, and affirmative action, more eyes than ever are on the U.S. Supreme Court, which has shown its power to shape important policy issues that affect all Americans. Bloomberg Supreme Court reporter Greg Storr looks ahead at which cases are likely to be of greatest consequence this term, some of which involve gun rights, speech on social media, and how much power federal agencies should have. And later, we look at former President Donald Trump's legal woes, already before the Supreme Court, thanks to an extraordinary request from one of the prosecutors. I'm Craig Gordon. Today on The Big Take, another pivotal year for the U.S. Supreme Court. Greg, the U.S. is approaching a record for the number of mass shootings that have occurred within the space of a single year, and the Supreme Court will be taking up several cases around the issue of gun rights. Let's start by taking a look at the case involving a Trump-era ban on bump stocks. What is a bump stock, and why are they currently banned?
A bump stock is a device that lets a semi-automatic rifle fire a little bit like a machine gun. And the Trump administration banned bump stocks. It made it a criminal offense after that horrific 2017 shooting in Las Vegas that killed about 60 people, where the shooter used bump stocks. And the question for the Supreme Court is whether the Bureau of Alcohol, Tobacco, and Firearms had the authority to do that, whether within this law that gives the ATF some discretion to ban things, whether this device makes a semi-automatic weapon into something similar enough to a machine gun that they have the ability to say that is illegal and it's a criminal offense to possess one.
Another gun case we're watching concerns a ban on, quote, dangerous people owning firearms. Tell us about this case.
This is a Second Amendment case, and it's potentially very, very important. If you recall, a year and a half ago, the Supreme Court said there's a constitutional right to carry a handgun in public. And as part of that, the court set up a really tough legal test where they said, we're going to look to history, and unless you can point to a regulation, a law within our history that shows there's a tradition of regulating this type of behavior, this type of firearm, then it violates the Second Amendment. And so the question here is a federal law that says if you're subject to a domestic violence restraining order, you can lose your gun rights. And so what the justices explored in arguments in November and are going to rule on sometime next year is whether there's enough of a tradition there of taking weapons away from people like the man in question in this case, who is subject to a domestic violence restraining order, for that to pass Second Amendment muster. The arguments seem to go pretty well from the standpoint of gun control advocates in the Biden administration. The court didn't seem like they wanted to go quite that far to say, no, you can't impose this type of gun restriction, but we'll see what happens when they rule.
So what sorts of other Second Amendment cases could this case be a prelude to if the justices were to rule one way or the other?
Well, certainly there are a lot of cases kicking around about things like restrictions on so-called assault weapons and large capacity magazines. Those are the kinds of restrictions that a lot of states and local governments had in place even before the recent wave of mass shootings. There are questions about whether those will survive constitutional muster. There are questions about whether somebody who is convicted of a nonviolent felony can have their gun rights taken away. That's the kind of thing that was very much at issue in the arguments in the domestic violence case, the question of who has a Second Amendment right, even if they've done something violent or nonviolent, something to evade the law previously in their life.
The National Rifle Association, often known as the NRA, is also involved in one of these gun cases. They are claiming that a New York State official blacklisted the organization, violating its free speech rights. What is the root of the NRA's complaint in this case?
So this is a First Amendment case. They're saying the New York officials violated our rights. They discriminated against us because they don't like our viewpoint when they pressured insurance companies not to do business with us.
So the NRA is essentially claiming they are allowed to exist as an organization and carry out, a position that some people might agree with and might disagree with, and New York State has no right to squelch that activity?
Essentially, they're arguing that regulators don't have a free rein to target us because they don't like what we do. and that is a quintessential First Amendment violation because the government is supposed to treat private individuals and organizations the same regardless of what their viewpoints are. If the government wants to express its own views on a matter, it's allowed to do that, but it can't punish us for expressing what we want to express and doing that by pressuring others, in this case insurance companies, to disfavor us.
Greg, you mentioned several First Amendment cases on this year's docket, and some in particular including social media and misinformation. 3 of these cases deal with the ability of federal entities and the platforms themselves to police misinformation. Tell us what's at stake.
There are 3 different buckets of social media cases this term. One has to do with Biden administration efforts to take down misleading posts about COVID during the height of the pandemic. And a lower court said the Biden administration violated the First Amendment by being too heavy-handed there and restricted the context that the Biden administration could have with social media companies going forward. And that could have big implications for the election. Now, that ruling is on hold, but the Supreme Court is going to take up the underlying question of whether the Biden administration could be restricted in that way. Another set of cases has to do with state laws, one in Texas, one in Florida, that restrict what social media companies can do to moderate the content on their site. So in both cases, those states say social media companies are disfavoring conservative viewpoints. And so they've set up all these rules to make sure that, in their mind, conservative viewpoints aren't disfavored. And so there are a variety of First Amendment attacks that the social media companies are pressing against those 2 laws. And then the final bucket of cases has to do with a variation of, if you remember back when Donald Trump was president and he would block people from his Twitter account. These are cases where officials at lower levels did something similar to that. They have private social media accounts where they talk about public events, public affairs, public issues. The question is, do they have the right to block people from posting comments on their social media sites if they're using them for at least quasi-official purposes?
All 3 of these cases would seem to have a great bearing on what kind of posts can be made during the 2024 election. How do you see this shaking out in terms of the election speech that both sides are going to be trying to engage in, whether that's Biden and Trump, Republicans and Democrats? Are we going to see a kind of a Wild West approach where things are wide open, or do you think there will be limitations put on it, especially after the 2016 election when Facebook and other companies played a pretty major role in some of the campaigns?
I would say that cases like these might have seemed more important before the social media companies started scaling back on their own how much they want to do to moderate content. For example, the case about the Biden administration. That will be very important in the election going forward. It will restrict the ability of the Biden administration, if they lose, to go to X or Facebook or whoever and say, hey, somebody is posting false information there. You might want to take a look at that. But to the extent that the social media companies aren't as interested in taking down misleading content, the effect will be a little less. Now, the Texas and Florida laws, they could still have a pretty big effect if social media companies are affirmatively required to take steps to make sure that conservative content isn't disfavored, isn't disproportionately taken down, but probably more at the margins than it might have been if we were having this debate before, say, the 2020 election.
Greg, the ruling against the Sackler family, of course, they are the owners of Purdue Pharma that manufactured OxyContin, is also being challenged. The central question there being whether or not the Sackler family could get a legal shield from future litigation through their settlement. What arguments are being made in this case?
So this is a case where the Biden administration and a guy within the Justice Department known as the U.S. trustee is challenging the settlement on the grounds that federal bankruptcy law doesn't let bankruptcy judges approve so-called non-consenting third-party releases. And to unpack that a little bit, the idea is people who might want to sue the Sacklers because they blame them for the opioid crisis can no longer sue them under the settlement. The Sacklers are shielded to a large degree from any additional liability in this case. The settlement as a whole requires them to put in something like $6 billion into the pot for victims and to fund opioid addiction programs. Some folks would like them to pay more. The Sacklers took a lot of money out of the company. A lot of that money is now offshore. And The question is whether this settlement is going to go forward and wipe out the ability of victims to keep trying to go after the Sacklers for their involvement in the opioid crisis.
What would a ruling against that plan change in current bankruptcy law?
It would change a lot. These third-party releases are a pretty common feature. So, for example, settlements involving the Catholic diocese, involving sexual abuse, and the Boy Scouts, they have provisions like these. And the arguments for them is that's the only way we're going to achieve this sort of global peace, is if we say we're settling everything, there's this big pot of money that will now be available for victims. And without this sort of tool, a lot of people think that big overarching settlements like that will no longer be possible, or at least not as easy to achieve.
After the break, will the court limit the power and reach of federal agencies? Greg, the Supreme Court is also reviewing several cases regarding the reach and power of some federal agencies. The Consumer Financial Protection Bureau, CFPB, as it's known, is under scrutiny for the way Congress delivers its funding. What is the criticism about the current funding model?
So the argument is, and a federal appeals court found, that the Bureau's funding system is unconstitutional because the money it uses wasn't appropriated by Congress. The CFPB gets its money from the Federal Reserve. In fact, the CFPB sort of gets to set its own budget. It tells the Federal Reserve, here's how much we think we need, and up to a certain cap, and that amount has always been approved. It's always gotten that amount of money. And so a very conservative appeals court, the Fifth Circuit, said the Constitution says that you can't spend money unless it's appropriated by Congress, and that hasn't happened here. And one of the issues in the case is this appropriations clause until now has only been used as a restriction on the executive branch. So the idea behind it, a lot of people will argue, is that, you don't want the president or some agency spending money unless Congress says it's okay, because Congress has the power of the purse. In this case, this is more of an argument that it actually restricts Congress, and it restricts its ability to set up this agency the way it wants with the level of independence that it wants. The court heard arguments back in October in this case. They were, perhaps surprisingly, pretty skeptical of the argument that this is an unconstitutional system. It's a novel argument, and it didn't really seem to gain a whole lot of traction. So at least coming out of that, it felt like the court was going to uphold the CFPB's funding system and let the agency continue as it has.
Greg, the CFPB is actually a relatively new agency meant to be a consumer protection agency at the level of the federal government with federal powers. Why did they create this rather unusual funding structure where it does seem to do a little bit of an end run around the congressional appropriation process?
Well, this was set up in the aftermath of the 2008 financial crisis, and Congress really wanted to give it independence and have it be shielded from political pressures so that it could do the work of protecting consumers. And so ever since then, opponents of the CFPB have been challenging various aspects of it. One issue the Supreme Court dealt with a few years ago was the notion that it was too hard to fire the director of the CFPB. And in fact, the way it was set up, when Donald Trump was president for the first couple years, he had a director of the CFPB who was appointed by President Obama. And the Supreme Court in that case ruled that the president had to have the ability under the Constitution to fire the director for any reason. And since then, the director has been somebody who was appointed by the president.
Greg, an agency that's been around a lot longer than that, the Securities and Exchange Commission, the SEC obviously regulates Wall Street, is also having the breadth of its authority scrutinized by the Supreme Court justices this term. What is the key enforcement tool that is under fire?
This is a case, and there are multiple arguments, but it's all focused on the use of what are known as administrative law judges. They're in-house judges. And the SEC, like some other agencies, when it presses an enforcement action, say somebody violated or some company violated the securities fraud laws, they can choose to go before one of their in-house judges, or they can go to federal court. And the main argument that's being made in this case is, when you go to one of your in-house judges, you violate the constitutional right to a jury trial. So this is a case of a hedge fund manager who is accused of defrauding investors. And he says, I have a constitutional right to make my defense to a jury. And there are a couple other arguments, too, also having to do with how easy it is for administrative law judges to lose their jobs, to be fired. But the main argument they focused on at the court was that jury trial right, and it did seem to get some traction. There's certainly a possibility that the court will say, at least when the SEC is trying to get money from somebody, seeking civil penalties from somebody, the Constitution's 7th Amendment guarantees them the right to have a jury trial.
There are 2 cases coming up that challenge something called the Chevron doctrine. What is that exactly, and how is it being challenged?
That is a really, really important doctrine for the field of administrative law. This case called NRDC versus Chevron from back in the 1980s, probably the most cited case when you're talking about fights over regulations. And what it says is basically, if there's a statute and the statute is unclear, like how much an agency can do, for example, how much power it has, if the agency interprets a statute, says it means X, the courts will defer to the agency, let it decide what its authorities are, as long as that interpretation is reasonable. And over the years, that has given agencies a fair amount of power to kind of define the scope of their missions. Now, when the Chevron doctrine was put into place, it was something that tended to help conservatives and Republicans. Justice Antonin Scalia was a big fan of the Chevron doctrine, but over time, it's become something that is anathema to conservatives and folks who don't like big government. So this is a case, or I should say actually 2 cases, where the Supreme Court, which has sort of been whittling down Chevron over the years, is going to consider overturning the Chevron doctrine and saying, nope, the agency doesn't get any special deference. We're just going to interpret the statute. And if we think it means Y, it doesn't matter whether the agency thinks it actually means X. If the court goes there, it certainly has the potential to make it much harder for agencies to issue broad regulations and do other things that affect American business.
Right. This strikes me as having enormous implications, as you say. In other words, every time an agency makes a regulation, a court could come along and second guess the agency. Doesn't that completely disempower the federal agencies?
I would maybe not say completely, but it certainly would take a lot of power away from them. There are narrower ways that the court can decide this case. They don't have to go all the way to overturning Chevron. But certainly, if the court were to overturn it, you add on to it, there's a ruling from 2 terms ago involving the Environmental Protection Agency where the court said, hey, if we're talking about whether Congress has given an agency a major power, this is known as the major questions doctrine. If we're talking about something that has a major political or economic impact, like, say, climate change regulations, the Supreme Court said, we're going to require Congress to be very clear, very explicit that it did mean to give the EPA or some other agency that power. And in that case, the Supreme Court said they hadn't done that.
When we return, the case against former President Donald Trump makes its way to the U.S. Supreme Court.
Special counsel Jack Smith is asking the Supreme Court to decide whether Donald Trump has immunity from criminal prosecution for alleged crimes he committed while in office.
Greg, the cases against former President Donald Trump also continue to move forward. Notably, this week we saw special counsel Jack Smith ask the Supreme Court to rule on Trump's argument that he's immune from prosecution. How is this unusual?
It's unusual because the last thing that happened on this issue was that a federal trial judge ruled against Trump, said you don't have the absolute immunity that you're claiming. Trump then appealed to the federal appeals court, the D.C. Circuit, and the special counsel, Jack Smith, is now asking the Supreme Court to bypass the appeals court level, go ahead and decide this issue itself, rather than having it go through the normal course of an appeals court decision and then the losing side appeal up to the Supreme Court.
What are the implications that a Supreme Court ruling, one way or the other, could have on this case?
It could kill the case if the Supreme Court rules against Jack Smith. This is pretty much an argument that Trump can't be prosecuted for anything stemming from efforts to overturn the election or January the 6th. Right now, trial is scheduled for March the 4th, and part of the reason Jack Smith said he went straight to the Supreme Court was that waiting for the D.C. Circuit to decide the case and then going to the Supreme Court could take many months, and he wants to move very quickly. Donald Trump wants to delay things. He's tried to get the trial pushed to after the election. And Jack Smith wants to have a trial as soon as possible. And with the election looming in November, he's making the argument that it's in everybody's interest for us to have certainty on this issue as soon as possible.
What are the historical precedents here? Is it common or uncommon for the Supreme Court to sort of jump the line and take a case before it's sort of made its way through all the different levels of appeals courts?
Historically, it's uncommon, although it's happened a lot more in the last few years for various reasons in both the Trump years and now the Biden years. Probably the best precedent for it, though, is back in the Nixon tapes case in the 1970s. That was a case where the Supreme Court reviewed a federal district judge's conclusion directly. And there was a criminal trial that was going to be on hold depending on what the court did with regard to requiring the Nixon tapes to be turned over. And the court ruled in a matter of a couple months. It agreed to take up the case, skip over the appeals court, and issued a ruling that let the trial go forward.
Greg, in that same case in the D.C. court, the judge put down a pretty tough gag order on the former president, barring him from commenting about the process and the personnel in the court. Trump is obviously fighting this, saying that he's essentially in the middle of a presidential campaign and he should be allowed to say what he wants to say as he seeks to return to the presidency. What are the chances that this particular issue could make it all the way to the Supreme Court?
There's certainly a significant chance. We're at the point now where we're waiting to see if Donald Trump will appeal to the Supreme Court. The D.C. Circuit in that case largely upheld Judge Chutkan's gag order against Trump.
The judge overseeing former President Donald Trump's January 6th case has reinstated a gag order. The judge temporarily halted it earlier this month after his appeal. Prosecutors say Trump has published intimidating posts on social media about prosecutors and potential witnesses. Trump has said that the gag order violates his right to free speech.
The gag order, as it stands now, restricts what he can say about witnesses. It gives him a free hand to criticize the judge, gives him a free hand to criticize Jack Smith. And there are some things he can talk about with regard to the case. But as you indicated, still seems to think that goes way too far in terms of restricting his First Amendment rights, particularly since he is a candidate. So the next thing that could happen there is he appeals to the Supreme Court.
Greg, in Colorado, one of a series of 14th Amendment cases looking to keep Trump off ballots is still underway. What would happen if the Colorado Supreme Court ruled against Trump?
That almost certainly would go up to the Supreme Court. The question there is this insurrection clause. It's in the 14th Amendment, put in there after the Civil War, largely thinking about people who were involved in the Confederacy. And the question is, can it be applied to Donald Trump with regard to his actions on January the 6th? And if it can be, who makes that decision? How does that happen? Do you need like a criminal conviction before it kicks in? So there are a lot of questions there. And as you said, there are a number of cases out there, 4 significant ones out there, where folks are trying to keep Donald Trump off the ballot. Not entirely clear the Supreme Court is going to need to jump in or decide it wants to jump in. But almost certainly, if a state court, say the Colorado Supreme Court, says Donald Trump cannot appear on our ballot because of the insurrection clause, that would almost guarantee the Supreme Court would have to take that up.
And finally, Greg, turning to the Supreme Court itself, after a series of ethics controversies, the court adopted a code of ethics for itself for the very first time. What does that entail?
It entails essentially putting in a different form the rules that the court says it's always abided by. The court was very clear when it did this that it's not changing anything. And in fact, it led it with a statement that said that we're dispelling the misunderstanding that we act as though we're unrestricted by any ethics rules. So it put them all in a form of a code of conduct that said a judge should do this and not do that. And all the justices signed it, agreed to abide by it. There is, importantly, no real enforcement mechanism for it. So one thing that some folks were hoping for was that there would at least be a panel of outside judges, at least an office within the Supreme Court that would vet complaints about the justices. And there isn't any of that. It remains up to the justices and really up to the individual justices to decide their own course of conduct. One of the issues with, say, like recusals, where, you have questions, to go back to January 6th, should Clarence Thomas recuse from the January 6th cases because his wife was involved in encouraging efforts to overturn the election? And that decision, based on the court's current practice, is going to be made by Justice Thomas himself. There's no mechanism for the court as a whole to make that decision about the activities of one of the members. So it did address one thing that people said the court should do. They now have a code of conduct, but in terms of actually changing any behavior on the court, not at all clear that's going to happen.
Is there any chance that the existence of this code of conduct would lead to investigations or probes of some of the justices' activity? You mentioned particularly Clarence Thomas, there's been some articles written about gifts he's taken from various wealthy folks. You mentioned his wife, Ginny Thomas, of course, was heavily involved in some of the conversations around overturning the election. Any reason to think this code of conduct would lead to investigations into that conduct?
Craig, there's just not a mechanism in here for that sort of investigation. So I think the answer to that has to be no. Now, will this have some sort of prophylactic effect? It might, some of the criticism of things justices have done have some sort of effect on them. Do they sort of accept that maybe some of the things they've done have cast the court in a bad light? Maybe. It's hard to say, and I think kind of the proof will be in the pudding in the next year or two as we sort of see whether or not justices are materially changing the way they're going about doing things. And with regard to what you're saying with Justice Thomas and his wife, no sign that either of them are backing down from the positions they've taken, but who knows, maybe things will change.
Thank you very much, Greg.
My pleasure.
Thanks for listening to us here at The Big Take. It's a daily podcast from Bloomberg and iHeartRadio. For more shows from iHeartRadio, visit the iHeartRadio app, Apple Podcasts, Bloomberg CarPlay, or wherever you listen. And we'd love to hear from you. Email us questions or comments at bigtake@bloomberg.net. This episode was produced by Sam Gebauer with production assistance from Michael Falero and Federica Romaniello. Hilda Garcia is our engineer. Our original music was composed by Leo Sidran. I'm Craig Gordon. We'll be back Monday with another Big Take. Have a great weekend.